My name is Michael Young, and I'm a lawyer who handles will contests, other contested estate and trust matters in Texas. One of the things that's unique to the contested cases on a probate court's docket will be a litigation scheduling order, or what's commonly called a docket control order. And so when a client hires me in a will contest, whether to contest a will or defend a will, or in a contested trust case, I'll explain to them the various stages of litigation. And one of those is that most courts these days, not all, but most courts will set what's called a scheduling order or a docket control order. And essentially what that does usually, and it depends on the particular court and the judge, is usually then the court will set a trial date, maybe 6 months in the future, maybe a year or more in the future, and then set various deadlines for the parties. In a contested estate or a trust, those deadlines typically will include deadlines to designate expert witnesses, which will often be doctors in a contested trust or estate when there's issues of mental capacity. Can often be experts that are lawyers on attorney's fees. Occasionally you can have lawyers who are experts on fiduciary issues. And the court will have a deadline for each side to designate their experts and to list in the designation generally who the expert is and what they're going to talk about. There will also be deadlines for discovery, and that would be the exchange of documents, interrogatory questions to each side, and for the parties to conduct depositions. There will often be a deadline for mediation. Most courts require mediation. The ones that don't strongly encourage it. And there are very, very few cases I handle these days that are contested trusts or estates that don't go to mediation. It's usually a good idea in these cases. Most of the cases do settle. And we'll talk with the other side, the other attorneys, as to whether or not the mediation should occur early in the case to try to save expenses and fees, or whether it makes more sense to do some discovery and designate experts and take depositions before we mediate. And it just depends on the specific case, the amount of money that's issued, and the feeling of the parties and the lawyers. But that's generally what a scheduling order is it sets a case for trial and then gives the parties and their lawyers various deadlines to meet. And it really just ensures that the case progresses and just doesn't sit there. Because courts these days, particularly now in Texas with the legislature, they don't like cases sitting on courts' dockets for 3, 4, 5 years without getting resolved in some manner, either by settlement or a trial and resulting judgment. If you're facing one of those cases, if you have questions about the process, feel free to give us a call.